Yes, today we will, good morning to all. Today we are discussing on case law from the Insolvency and Bankruptcy Code. It is an order passed by the Honorable High Court of Gujarat. The matter of Amit Dinesh Chandra Patel, Reserve Bank of India. Its observation is the lender banks must furnish copy of audit report before classifying loan account as a fraud. So, before classifying the loan account as a fraud, firstly there should be a forensic audit. The bank must conduct a forensic audit and report has to be prepared and it should be submitted by the forensic auditors, empaneled forensic auditors to the bank, and bank has to forward the copy of that audit report to the concerned company and seek explanations. And after receiving the explanations and information, anything further information, then if it is satisfied that then only it can be classified as a fraud. Without giving any opportunity of being heard, the bank cannot themselves say this account as a fraud or declare the company's bank account as a fraud. And they cannot go and come file a case. So this is the order passed by the Gujarat High Court. Let us see what's the case is. Amit Dinesh Chandra Patel, petitioner are the promoters, suspended directors and shareholders of Syntax Industries Limited. On 6/4/2021, the company was ordered into a corporate insolvency resolution process under IBC. The company loan accounts were declared as a fraud by the consortium banks. This is the respondent banks. The contention of the petitioners. Our petitioner argued that no opportunity has been afforded to deal with the forensic audit report under supplementary forensic audit report. They contended the same is a mandate issued by the Supreme Court in State Bank of India and others, versus Rajesh Agarwal and others, and argued that pertinently, except for the sharing the observation of the draft forensic audit report with the petitioners, neither the copy of the forensic audit report nor the supplementary forensic audit report was provided to the petitioners. So verdict of the court is that, let us go, scroll down. The Gujarat High Court allowed the petition and held that the lender banks must provide a reasonable opportunity to the borrower by furnishing a copy of the audit reports and allowing them to submit a representation before classifying the loan account, before classifying the account as a fraud. High Court placed reliance on the provisions of Master Directions of 2016 on frauds and observed that Master Direction of 2016 on frauds, and more particularly Chapter 8 titled Loan Frauds, New Frames, deal with the procedure to be followed by declaring the account as a fraud. Further, Class 8.9.4 provides for the decision to classify any standard account or NPA account as a RFA or fraud at the individual level, and responsibility of the bank to report the RFA or fraud status of the account on CRILC platform so that other banks are alerted. It is also observed that Class 8.9.5 envisage the completion of forensic audit within a stipulated period. Also provide that in case the decision is to classify the account as a fraud, the RFA status shall be changed to fraud in all banks and report to the Reserve Bank of India on CRILC platform within a stipulated period. The court pointed out that Supreme Court in the State Bank of India and others, Mr. Rajesh Agarwal and others, answered the issue as to whether the principles of natural justice should be read in Master Directions of Section 2016 on frauds. They held that the principles of natural justice and more particular rule of ad alteram partem has to be necessarily read into the Master Directions on frauds to save it from the vice of arbitrariness. The apex course emphasized on serious civil consequences of the classification of account as a, scroll down, fraud for the borrower, and thus held that directions must be construed reasonably by reading into them the requirement of observing the principles of natural justice. It provided that ad alteram partem, therefore, entails that any entity against whom evidence is collected must be provided an opportunity to explain the evidence against it, be informed of the proposed action, and be allowed to represent why the proposed action should not be taken. The High Court noted that Apex Court also emphasized that the mere participation of the borrower during the course of preparation of a forensic audit report would not fulfill the requirements of natural justice. The High Court highlighted the Supreme Court observation that there is an application of mind to the facts and law by the lender banks while deciding to classify an account as fraud. Further, the lender banks, either individually or through joint lenders forum, have to decide whether a borrower has breached the terms and conditions of a loan agreement, and based upon such determination, lender bank can seek appropriate remedies. The High Court noted that thus the principles of natural justice provided for serving of notice to be Notice the borrower, an opportunity to explain the submit a representation must be given in light of the forensic audit report before the classifying the loan account as a fraud or the master directions on the frauds. In conclusion, the court ruled that the present the respondent violated the principle of non-strict justice. That's it caused and set aside the respondent decision declaring the account of the company as a fraud. It remitted the matter and directed the respondent to furnish the relevant copy of the forensic audit report and supplementary audit report, giving opportunity to submit the representation. So this is the order passed by the Honorable Gujarat High Court. See, in section 43 and section 66 of IBC, you know that the preferential transactions and fraudulent transactions. Section 66 deals with the fraudulent transactions. It also says that within the forming an opinion that there is a fraud has taken place, there is a time limit is given under regulation 35A something. I think so. Under the regulations of CARP. These fraud reports has to be done. That is, when there is a suspected fraud is there, where the resolution professional thinks, then he must obtain a report from the forensic auditors. He should conduct a forensic audit by the forensic auditors, and he has to obtain a report and form an opinion that yes, there is a fraud has taken place. Then within 115 days, he has to file a case in the National Company Law Tribunal, that is application before the National Company Law Tribunal against the corporate debtor and the persons who have benefited out of the transactions. So what is the basis that there should be a forensic audit report, and report has to be provided, a copy of such a report has to be provided to the respondent, that is to whom against the case is going to be filed, and the opportunity of being here should be provided. Without this providing this opportunity, they cannot come to a conclusion that it is a fraud. Okay, so this is for today. If you have any doubt, you can ask me.
No, sir.
Okay. Thank you.
Anyone else has any doubt? I think no, sir.
Okay.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, sir.
Thanks to everyone.